Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matias Baker Masucci.
Welcome, everybody, to another very exciting episode of our show. Today, we have a returning guest, Paul Deloughery. Paul, thank you for being back on the show.
Hi, Matias. How are you doing today?
I'm doing pretty good. Paul is a managing attorney at Probate Made Simple. So we have heard in the past episode his incredible adventure, and he's a crusader for helping people to overcome these challenges, which is a very important aspect of people's lives. Let's delve right into the questions. The first question I wanted to ask you, Paul, is if you could share a challenging probate case you've handled and how you tailored the approach that led to a successful outcome.
So over the years, I've had hundreds of interesting probate cases, and it was a little difficult to think about that because you sent me that question ahead of time. Right. But I have one that I'm working on right now, so I'm just going to talk about that.
Yeah, absolutely.
Because your show's about real estate, and so I have a case involving a house where two investors went in and bought this house out of, I think it was a tax sale back during the 2008 GFC and the financial crisis. And it was two owners. One lived out of state and had a corporation, and then the other one had an Arizona LLC. And that was back around the time. So doing the title research on this was interesting because back around that time, I didn't even know that this existed, but people were doing double escrows. Do you know what I'm talking about?
Yes, I know exactly what you're talking about.
So I think these guys were doing that kind of a game. And for the listeners, in case you don't know what I'm talking about, the double escrow is, and I don't suggest you doing this because this is not legal, but where you get lender commitments on a property from two different lenders, and then you do the closing date on the same day. So then you get the loan money all on the same day, and it's a big windfall, until they find out. Well, actually, I'm not sure how they find. Yeah, I'm not sure how that works out. But
actually,
anyway,
when they find out two trust deeds get recorded, at least in California. I know Arizona it's a little bit different because you have, instead of trust deed, you have mortgages. But
we do.
Oh, you do trust deeds?
Yeah,
okay,
yeah,
these are trust. So yeah, that's how these things get caught.
Well, and I guess maybe the idea is that they fix it up and flip it fast before anyone finds out. Correct. Or something. Okay. Well, so in this case, they died. And the years went on, and the family, well, the best we can figure out, the one guy didn't have any family, but the other one did. And so just to answer your question, like, what do we do in that case? I mean, it's we just kind of work it through the system. But that case is interesting because we have a out of state, it's actually an Illinois corporation, so we need to figure out a corporation we can still serve. It's right. What do you call it? It's registered here in Arizona, so it's registered, so we can serve the corporation. But then, at some point, we're going to have to figure out who actually owns that corporation. But we're not going to, that'll be down the road. Right now, what we're actually doing is the partition. And partition is interesting. I run across that all the time.
Yes.
So, and I don't know, let me know if I'm going off on a tangent here, but
No, we should talk about this. Actually, let's talk.
Okay.
We've had the subject of partitions on the show before, but for those people who did not listen to that episode, tell our audience briefly what a partition is and the circumstances in which it is done.
Yeah. So the concept of a partition goes back centuries, and the idea would have been like way back in the frontier days when, most people, if they had land, it was farmland. So then if the owner died and the family ended up inheriting it together, they would want to not own, this farm collectively, but they would want to have it partitioned. So, actually sectioned off, and you'd get a surveyor and,
Right.
get the 40 acres and figure out, okay, divide it somehow, and then everyone gets their piece. Well, most of us aren't farmers anymore. Most of us, if we have property, it's going to be a house. So there's also a section in the statute, and I'd imagine it's the same thing in California or other states, that there's a provision that if you can't realistically just cut the thing in half, then you sell it and divide the proceeds that way. So what we're doing is a partition by sale, and we appoint a realtor as the commissioner, and a fancy word for a real estate agent, but it's actually court appointed and has instructions, from, there's going to be a court order that says you have to sell the house and the proceeds have to go here or here or whatever.
Yeah.
Maybe the proceeds go to the court, and then the court figures out, where to send the money to or whatever. But
There's something
that's
I want to
basically
say
what we're doing
to our audience, which is very important to understand why it's a partition by sale. When you divide a property, this is the realtor perspective, the real estate broker perspective. When you divide a property, half of a house, it's not really worth half of a house, because if you try to sell half a house, whoever's going to buy that half a house is going to have an issue because he doesn't own the other half of the house. So it's very important to understand that when you do a partition action, especially in the cases of that, when there is inheritance and things like that, that is why often the route is, we partition by sale. We don't just give you half of it and you can try and sell your half. Maybe that can be done, like you said, with farmland, that can be done. Maybe that can be done with multi-unit if you do tenancy in common. But those things are, it is advantageous for the beneficiaries that the partition happens through the sale rather than cutting the house in half.
For sure. Yeah, for sure.
And by the way, I have sold partial interests in real estate. Like sometimes you have 50% of it going through probate and the other one doesn't get probated. So you have to sell half of it as a probate and half of it as not. So sorry for the tangent, but people are very interested in this type of thing. But let's talk about the circumstances that you have. You're doing a sale through partition. Let me ask you a question that kind of ties in directly into this. Your client had a corporation or an LLC or whatnot. Now we know when we talk about probate, when it's in an entity, it's the interest that you are going through probate, right? Because the deed of the house was not in the person's personal name.
Right. In this case, we're probating. Well, I had my client. My client is one of the sons of the owner of the LLC, and so he's appointed as personal representative. That's what it's called here in Arizona, or executor in other states.
California.
So he's appointed, to be in charge of the estate, and part of the estate is this interest in the LLC. So from that standpoint, then he's authorized to act on behalf of the LLC, seeking a partition of the real property.
Perfect. That makes sense. Very good. Great. So good luck with that case, because it's still on your desk. This is an example of a case that's still on your desk. Now let's talk about common probate misconceptions you have encountered, and how do you address them?
Well, and there's a lot. I mentioned in the last time I was on, I did a little PDF that you can put a link to if you want it.
Would love to, of course,
for listeners. Okay, sounds good. But the first two things, so it's about 5 probate myths, and the first two are this. Number one, I think, is that if you have a will, what is it now? If you have a will, it avoids probate, and that's not true. And then the other one is, if you have a will, then you have to probate it, and that's also not true. So here's the thing about that. To give an analogy that maybe the listeners would understand, think about it like a check. Okay, if I give you a check, to for $50. You can't just take that $50 check and go to the store and buy things with it. You have to actually deposit it at the bank. There's actually a routine you have to go through in order to have access to the money. Right. And it's kind of the same thing with a will. A will by itself is not, to use lawyer speak, is not self-executing. So you have to actually file it with the court and have the court approve it, and then name someone, possibly probably the person nominated in the will to be personal representative, who actually has authority to do things on behalf of the estate. So anyway, it's a lot of technicalities there, but that's how that works. So and then sometimes if you have a will, we get this question, like let's say the deceased person left a will, but the bank accounts were all joint with the surviving spouse, say, and the house was joint with the surviving spouse, and there aren't any other assets, like everything was held in joint tenancy with right of survivorship or payable on death or something. Well, in that case, the will doesn't actually do anything. And it can be frustrating to me and to family members and I run into this where the will says that half of everything goes to the surviving spouse and the other half goes to the children. But then, again, the bank accounts and the house and everything all go to the surviving spouse, because they're held jointly. So the will in that case doesn't actually do any good. Like it just literally doesn't do any good. You can probate it, you can file it, you can all that kind of stuff, but joint assets are what's called non-probate. So they go around the probate system.
That is I'm so glad you explained that. And I'll tell you why. In California, when you have a will, obviously I was going to say you have to probate it always. A will have to be probated. But you're right. The right of survivorship supersedes the will. So if you have all the assets, which most people do with your spouse, you have, joint tenancy because you buy the house together, chances are, in your accounts as well. When you do your investment account, your broker will ask you, do you want to check this box for right of survivorship or this and that? So that's great. This is a perfect example and a great explanation in the fact that if you have a couple and only one party passes away, it doesn't automatically trigger the will that says that the children inherit, et cetera, if all the assets are held jointly. Right.
Well, and let me clarify something. You said that a will always has to get filed, and I'm pretty sure this is also true in California. That in that case where everything is joint, if you have a will, you don't need to file it because it wouldn't do any good.
Right.
So
yes, but what I was trying to say is that when you have a will, and if all you have is the will, there's no way around probating it because that's essentially what probate is. It's the process of provare. As an Italian, I remember the Latin probare, to prove the authenticity of the will.
There you go. Where are you from in Italy, by the way?
Right outside Milan, a town called Novara.
Okay.
From the north, even though my entire family is from the south. But this show is about you.
Yeah. Well, we'll have to maybe talk again because this sounds bizarre, but I own the Carazzi Foundry. It's a historic art foundry in near Naples, Italy. And it ended up going through the bankruptcy system. So I'm actually waiting for some money from the bankruptcy court in Naples.
Oh, absolutely. Yeah. Let me know. I love, and when people go to Italy, I actually love giving them little towns that they can visit to avoid the touristy spots. Mm-hmm. So that's great. Let's continue our conversation about probate. Let's talk about this. When estate planning isn't in place before a loved one passes, in that case, nothing, no will, no nothing. They just didn't think about that, which is a kind of a common occurrence. What steps do you take when somebody comes to you and says, "Look, Paul, my dad passed away, and he didn't have a will, he didn't have anything. What should I do?"
Well, the main complicating thing usually is just figuring out who is going to be in charge, who is going to be named as personal representative.
Right.
Now, if there's only one child, no, let me back up. Usually, it would be the surviving spouse in that situation who's entitled to be appointed. If if there's no surviving spouse, the person was single and they had one child, that's pretty simple. It's going to be the child. But when you have multiple kids, then that can be an issue. And when you have multiple kids who are not children of the surviving spouse, that can also be an issue. You can have fights there. But unfortunately, just the statute, and this is pretty typical in the various states, that the surviving spouse is going to have priority over the children. So, they can kick and scream and all that kind of stuff, but it unfortunately just is the way it is. But yeah, that's the hardest part, is if there's going to be multiple children or multiple people are entitled to be appointed, we have to decide, are you going to have two or more appointed jointly? Because I don't think that's usually a great idea, because then then everyone has to go to the bank together to open the account, and everyone has to do this, and everyone has to agree, or whoever's appointed, if there's multiple ones, they have to agree on the realtor, agree on this, agree on that, and all that kind of stuff, and it can complicate things a bit. But other than that, the rest of it actually goes fairly smoothly. So the statute just says who gets what, and the rest of it doesn't really change too much in terms of dealing with creditors and all that kind of stuff.
So this is a point that I'm going to actually make, because I've talked about it on the show a lot. If you are living and you don't decide what is going to happen to what you own when you die, then the government will. So if you have disinherited people that you don't want to get your money and things like that, you don't get to decide that. Just like you said, the statute decides. If maybe you planned, I don't know, maybe one of your kids is a drug addict and you don't want them to have access to the funds as much as the other kids. Unfortunately, the law is not going to be they're not going to make that discretionary decision unless you take, like you put the person under conservatorship or whatever the circumstances may be. But that's a good thing to remind people. Then if you don't decide before, then the law will decide for you after, which is exactly an example of what you gave. Let me move on to another question. What innovative strategies do you use to effectively resolve probate matters for your clients?
I just reached for my notes because I wanted to. I made some notes about this. Yeah, go ahead. You were going to say.
Yeah, no. I said I know it's a bit of a generic questions, but I'm interested if there is something that over the years in your practice. I'll give you an example to kind of help you reach. So I generated checklists and workflows for my listings, like order the preliminary title report, did this, right? At the beginning, I had to learn on the job, kind of like, okay, we got to get this, we got to get that, contact escrow. Even simple things like, how many, when you to work with the buyers, how many times do you want to receive an email with new properties? Like, that's a question that now you ask, but at the beginning, you're just like, okay, get it every day. We'll see what you say. You know what I mean? So over the years, what are the things that, have helped you streamline your business?
Well, I mean, for starters, we've gone all in with technology. So we're 100% cloud-based. Nice. We've automated as much. I mean, well, I can't say we've automated as much as we can. It's always a challenge. It's an ongoing project, but we're in the process of always trying to automate more and more. And just like outside of technology, my own personal approach is, I guess there's a couple of things to it. Yes, we have checklists and all that kind of stuff, but the one thing, I'm a big believer in transparency to the heirs, because frankly, that I think that short circuits a lot of conflicts. Meaning, okay, take two different situations or the same situation handled two different ways. Okay, someone dies, there's kids, and they're expecting an inheritance. Okay, situation one is where they don't hear anything for a year, and then they're sent a letter with a check saying, here's your inheritance. Well, I mean, that actually happened to me with my grandmother back when I was a kid, and I was like, well, I have no idea if if this is legitimate, or like I have no idea. So okay, I mean, back then I was 18 or something like that, and I just deposited the check and that was that. But I mean, anymore, people are a lot more savvy now and skeptical. and that just doesn't fly nowadays. That they would just demand more information. So giving copies of bank statements, copies of this or that, as much as possible to so that they have all the information, hopefully to feel like they're in the loop, and all that kind of stuff, and communication in general, trying to update all of the heirs with information about the progress and all that kind of stuff, so that they feel more involved. I think that helps build trust. That really helps. It helps avoid ending up in probate court, because the one thing we want to do is avoid court if at all possible, because I see court as and I have to say I do a lot of probate litigation in my practice, because I know we're called, what we do is probate made simple, but unfortunately sometimes things just don't end up going simply. And
right.
The litigation route, I would call it kind of like a nightmare roller coaster, amusement park or whatever. Once you get on, it's really hard to get off. You have to just kind of go through the process, unfortunately. So if you can avoid that roller coaster ride, it's good to do that.
That makes total sense. Let me ask you another question. Let's talk about people who are hesitant to take any action concerning estate planning. What do you tell those people?
I would say to do it as a courtesy to your loved ones. I think it's very common for people just to say, well, why should I care? I'll be dead. I hear that a lot. Why should I care? I'll be gone. The kids will figure it out. Who knows what that means? That's just being really willfully ignorant about what's going on. And to take the example I gave before about, maybe you actually wanted things all divided, or somehow, or you wanted this one family heirloom to go to this person, or
right.
that kind of thing. Well, the reality is, if there's just to give an example, if there's a surviving spouse, the surviving spouse is going to make all the decisions about that. That's the reality. Okay.
Right.
Usually she is going to have control of the house, and have, the law may say that personal property is supposed to be distributed in kind, meaning that the heirs or whoever are entitled to, heirs, because you're saying that there's no estate plan. So, the kids or other family members would be entitled to family photographs and other mementos and that kind of thing. But the reality is, the surviving spouse can easily just throw that stuff away. And what are you going to do? Go to court and say she shouldn't have thrown the photographs away? I mean, the court can't recreate photographs,
right.
or other things like that. I mean, and frankly, the court can't do anything. The court's going to say, okay, what's the value of the photographs? Because they can issue a judgment. So,
right.
I don't know, 50. What's the value of old photographs?
Right.
to you it's fine, but the market value is probably nothing. So,
right.
Just do it as a courtesy to the family. That's what I would do. I mean, and the other thing is, that's how you're going to be remembered. That's the reality. You may have a great relationship with your kids right now, or the other family members right now, but if you leave a mess, that's what they're going to remember for years and years and years, and that's what their kids are going to remember. So, your whole legacy is going to be leaving a disaster.
Thank you for sharing that. I love how you simply you put it and explained it. So, if you care, do some estate planning. All right, before I let you go, Paul, I want to ask you a question that I ask all my guests. As I said, if people want to know about your story and inheriting, $28 million, which became 14 after paying taxes, and what happened to you, please go listen to the other episode. Right now, what I wanted to ask you about is your journey of becoming an attorney, and then specifically practicing in probate law. When you were a little kid, did you want to be an attorney?
Oh boy. Well, this is going to get embarrassing. So, growing up, we lived in Spokane, Washington, and my dad made it's not a treehouse, but he made kind of like a backyard fort for me, and it was awesome. It was 8 feet off the ground. had a ladder going up to it, and like he went all out. There were windows on two sides. There's a little porch. There were windows on two sides that matched. They matched the house windows. The roof matched the house roof. Like, you know, it was painted the same color. It was really cool. And I had a desk in there. And what did I do when I was playing as a child? I had paper clips and a stapler and papers and pens. And, you know, I forget how old what would I would have been, 7, 8 years old. I mean, yeah, I ran around with the neighbor kids and stuff too. But, you know, if they were busy, I went up in my little fort and I don't know what I was drawing and stapling. And I guess probably because my mom was a nursing professor. And so sometimes she would take me to work, and you know, there were no toys in the at the university where she taught at, you know, for kids or whatever. The only things to play with were staplers and pens and paper. And so I grew up with that. So for me, it's just perfectly natural. It's my world.
That's awesome. That's wonderful. All right. Before I let you go, actually, let me ask you one other question that I want to know. When you went to law school, did you know that you were going to practice probate law? No,
I was going to go into either health law or running a business. And actually, yeah, right after law school, I was a part owner in a home health agency. So that's what I was going to do. But yeah, no matter what I've done, I've been involved with families. So I guess that's the connection.
That makes sense. Thank you. It's been such a pleasure to have you on the show. One last thing, before I let you go, please do tell our audience how we're going to have your information in the show notes. We're going to share your PDF, but do tell our audience, what is the best way to get a hold of you?
Oh, simplest way, just go to probatemadesimple.com, and
Perfect.
you know, there's a phone number there. You know, there's a way of contacting me.
Excellent. Great. Thank you so much for being on the show. It's been such a pleasure. Thank you, everybody who has joined us, and we'll see you in the next episode. Bye.
All right. Bye, Matias.
Thank you for listening to the Probate Realtor Show. Find more episodes and interact with us at probaterealtor.la. That's probaterealtor.la. Listen, ask questions, and get results. Don't forget to like and subscribe. The Probate Realtor Matias Baker Masucci is a licensed real estate broker in California, DRE number 020547763. Any legal information provided is for informational purposes only and not for the purpose of providing legal advice. Contact an attorney to obtain advice with respect to any particular legal issue or problem. We make no guarantees as to the accuracy of any information. Thank you again for listening, and we'll see you in the next episode.